Hi there, I'm Savannah Mexto with Mannor Law Group, and I'm excited to welcome you to today's estate planning webinar with elder law and estate planning attorney Robert Mannor. Today's webinar will give you a solid estate planning strategies that can not only help you preserve more of your wealth for your heirs or charitable causes, but can also help your loved ones avoid the burden of unnecessary taxes, expenses, and delays. But first, here's some quick information about your presenter, Mannor Law Group. Mannor Law Group is a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's honored in 2020 as both a super lawyer and leading lawyer by both of those peer review lawyer rating organizations. Bob is currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. But before we get started today, I wanted to share a quick disclaimer. Now, even though Bob is an attorney, today's webinar will not give specific legal advice. If you do have a question about your unique situation, I encourage you to contact us after the webinar. If you do have a general question during today's presentation, please use the question box. We will save time to review questions during the webinar. If for some reason we don't get to your question, we will contact you after the presentation. Lastly, today's presentation will be recorded, and the replay will be sent out tomorrow so you can share that with your family, friends, or anyone who you think could benefit from hearing this information. Now, without further ado, I'd like to welcome Attorney Bob Mannor.
Hi, folks. We're going to get right into this here. So I look at this topic as two questions, really. And I point this out simply because people forget one of the questions. And when we're talking about estate planning, it really comes down to what if I die and what if I don't die? Now, a lot of people look at estate planning with the question of what if I die? That's a really important question. Obviously, we're going to get into all of those issues. But a second important question is, what if I don't die? Meaning, what if I get sick? What if I had dementia? What if I had a stroke? What if, any of these things? And estate planning is very much about that too. So we're going to start off on the what if we die. That's what most people are thinking the presentation is about. But we're going to spend a little bit of time on what happens for the rest of your life too, because that's just as important. And there's some key things that people always forget about when it comes to the second part of it. What if I don't die? So let's get right into it. The first question, and I think this is a great question, and you'll see I have the crystal ball there, or the magic 8-ball, how to control who gets what and how. Now, why? That seems like a pretty straightforward question, right? Why is there a magic 8-ball there that says, hazy, try again later? Because you would think that's a pretty obvious question. How do you control who gets what? A lot of people say, oh, well, I'll just put beneficiary designations on things, right? Or I'm going to put my kid's name on the account, which is very, very dangerous, by the way. But the point of this, and why I think that this is really interesting, and you got to kind of think this through a little bit more, is there's a lot of things we don't know yet. We don't know when are you going to die. So we don't know who your beneficiaries are because we don't know when you died. It could be tomorrow. And most people do their estate planning or listing beneficiaries on accounts and things like that as if they were to die tomorrow. But the reality is most of us aren't going to die tomorrow, right? We aren't going to die tomorrow, and it's going to be, oops, not sure what happened there. It's going to be, there we go. Okay, that things may have changed quite a bit between the time that you put a beneficiary designation or a joint owner or draft your will and the time period for which you actually die. The other thing is, what if you or your spouse got dementia? That's going to change things dramatically, and we're going to have a plan for that because it's happened so often. In fact, the statistics are staggering how many people will be dependent on somebody else before the end of their life or at some point before the end of their life. So this is really key and really important that we actually have planning, and you can't putting a beneficiary designation on there, putting a kid's name on the account, that's not going to solve that problem. Most of the time, doing a will is not going to solve that problem to say, well, what if something goes wrong during my lifetime? What if I have a massive stroke? What if my spouse has a stroke? What if they end up with Alzheimer's or dementia? So these are things that we have to think about from the standpoint of doing real estate planning. A lot of people will just consider just kind of doing it piecemeal, and they'll say, okay, well, I've got this account and it's going to go this way, and I've got a beneficiary on this account, and I'm going to put my kid's name on my checking account, and I've heard this thing called a ladybird deed for my house. That's all very, very piecemeal, and it doesn't really deal with having a plan that's going to adjust and change depending on the circumstances. So that's a big point of this, is that if you're trying to do piecemeal estate planning, or just kind of putting things together in such a way that as if you died tomorrow, you got to remember, hopefully it's going to be 30 years, 40 years, 50 years. I always, don't want to have people, my estimates be too short. So depending on your age, though, we don't know. It could be quite a long time. I have lots of clients that are in their late 90s and a few in their hundreds. And so it's one of those things that we should have a plan that's going to be flexible enough to deal with the situation, because we don't know who your heirs are yet. We don't know who your beneficiaries are yet, because you're alive. And we don't know that until you die. We also don't know how much money you'll have, or what assets you have, or what types of assets you're going to have, because we know what we have now. But 20 years from now, can you say that you're going to have those exact same assets, or that you're going to have those exact same types of assets? They're going to be the same taxable situation. They're going to be the same dollar amounts. They're going to be, the same types of accounts and how they're titled and everything else. You really can't. And so putting beneficiary designations, things like that, is not sufficient. And even really a will is often not going to be a very thorough answer for this. The next thing, we don't know what happens now. I mean, we can judge it based on what happens now, or we can judge it based on, when we actually have real information. So the question is, what's happening in your children's lives? So assuming your children are your beneficiary, or whoever your heirs are, but what is happening in their lives? When you die, are they going through a divorce? Are they sick? Are they in a nursing home? Are they in the middle of a lawsuit? Are they having some other issues? We don't know what's going on in their lives, because it's 20 years from now. They might not be alive. We don't like thinking about that. We assume that the parent's going to die before the children, but it doesn't always work that way. And so this is something that's very important to say, okay, we need to build into this plan, this estate plan, that's going to have sort of a master plan. So we kind of think through these things, but we don't have to make all these decisions now. We can have that flexibility to be able to deal with it, that at the time of your death, your child is going through a divorce, your child is in the middle of a lawsuit, or they have their own health crisis, or they've passed away before you. And when people try to skimp on their estate plan and just do their beneficiary designations, or a will, or a form trust, or anything like that, often it's not going to be able to answer the questions that we don't even know what the questions are yet. So we really have to build a thorough plan, and we're going to talk about what that looks like in a second here. One of the things that when we get into this is, what are the changes between now and then? And so if you imagine 20 years ago, so let's say that you die in 20 years and you think about your life 20 years ago. Well, my suspicion is things were a lot different back then. Maybe where you lived, maybe where your kids lived, maybe what their marital situation is, maybe their financial situation, maybe their relationship between them and the grandkids. And one of the things that we have to look at is sometimes when parents die, it's actually best to have the inheritance passed not on just to the kids, but on to the grandkids. But you don't know that right now. Right now you may say, oh, no, I know that they would want that because they are, they would need the money. But you have two kids, a boy and a girl, Susie and George. And Susie and George, right now, if you died tomorrow, they would want that inheritance. But maybe in 20 years, Susie and George say, I don't really need it. I'd like to pass it on to the grandkids, and have that be a possibility. Having that built in where they could make that decision is going to be very important and very valuable, rather than just saying, okay, we're going to make all our decisions as if nothing ever changes. So a lot of these things are things that maybe you've thought about, maybe you haven't thought about, and you see that you have an opportunity to have a quick 15-minute interview with us, because all of these things are going to be family specific and specific to your needs. So feel free to click on that at any point and schedule a free 15-minute call with us just to kind of talk this over with us, decide whether it's something that you want to interview us about. We're going to interview you about, deciding if it's something that we want to come up with a comprehensive plan for you or not. So you'll have that opportunity to schedule that 15-minute call at any time. So let's get into some of the documents here. So this is really important, and I really like this this graphic here, because this kind of shows us some of the things that we don't always think about. So what happens when, right? What happens when? And what I mean by that is, if you have legal documents, so which I assume some of you may already have some legal documents, and they may even be good legal documents. But I want you to understand what those legal documents do, and then I'm going to talk to you about some of the changes that you might want to make, or updates that you might want to make it a little bit more specific. But let's start off with the basics. So for the most part, the legal documents and legal processes are going to be divided into two different categories. It's either going to be lifetime or after death. And so it's important to recognize what documents or what legal processes we use for what purposes. So if you're alive and you get sick, or it's inconvenient, or you want to have somebody else be able to sign a check for you, or show up at a real estate closing for you, or just kind of help you out with your finances, maybe make sure that there's somebody there that's going to be able to pay your bills for you if you were in the hospital, something like that, it's either going to be a durable power of attorney or a court-appointed conservatorship. So in Michigan, we have this thing called conservatorship. A lot of people confuse that with the word guardianship, and in fact, in some states, they call it guardianship, but in Michigan, we call it conservatorship. And that's going to be over the financial matters, okay, over financial decision-making. So durable power of attorney for finances or conservatorship. I will readily admit I have a bias that with families that have people that they trust and have people that they love, I'm always going to recommend we stay out of the court process. The court process is there. It's important. It's necessary. It's there for a reason. But if there's a way that we can stay out of that process and have the people that we love and trust do it, and you've made those decisions as to who that is, then I highly recommend that we consider the durable power of attorney process over the conservatorship process. There's also the possibility of that you could get to the point where you're not able to make your own medical decisions. Well, when would that be? Because in theory, you should always make your own medical decisions. Even if you're old, even if you're sick, you should make your own medical decisions. That's the bottom line. That's what the Constitution says. You have the right to self-determination. And so having the right to self-determination, you always make your own healthcare decisions, including things like life support and end of life and being on a ventilator or things like that. So when would this even apply? And the answer is there's really two categories. Either you're unconscious, you're in a coma or unconscious, or the doctors have determined that you're not capable of understanding the decision making. Okay, so that's it. It's either you're unconscious and you're in a coma, or two doctors, typically it requires two doctors, have determined that you're not capable of making the decision anymore. Unless one of those two things apply, you should be making the decision with your doctors. Okay. And so if we don't have the healthcare power of attorney set up, sometimes called a patient advocate, then we're going to have to go to court and get a guardianship. And the judge is going to appoint somebody to make those decisions. Now, when it comes to the guardianship conservatorship situation, so sometimes when people go into court, they get both of those. Guardianship over the person and medical decisions, conservatorship over the financial. And we've seen recently, in the last few years, a lot of concerns and a lot of complaints about this because there were a lot of judges that were bypassing the family when there was family that was available and willing and potentially capable, at least it appeared they were capable, and judges were bypassing them and picking court-appointed administrators. And so there's been lots of abuses, so much so that the abuses have been made on the news, and that, money was being directed and houses were being sold, and there was it seemed like there was some bad dealings going on. So much so that the governor and the attorney general got involved, and they have this task force that is designed to try to fix this guardianship conservatorship situation. So they're making some progress, but all in all, kind of, if you have somebody you love and trust, I'd rather have that set up ahead of time and make sure that we've given them clear instructions as far as what you want and make sure that we have that in place. But you notice that circle, that's the lifetime circle. So sometimes people think that because their mom's durable power of attorney, that they'd be able to go to the bank account and they'd be able to pay bills after mom dies. And the truth is, none of these things last beyond death. The power of attorney, the healthcare document, guardianship, conservatorship, all of those end at the second of death. They do not have any authority beyond that. And that's when we come into this after death circle. In the after death circle, well, maybe we're going to have a will, which we'll talk about in a minute. Typically, the will means we're going to go through probate. Now, some people will say, well, you know, my mom had a will and we didn't go through probate. So I don't understand what you're saying here, Bob. How did my mom have a will and not go through probate? And what I'm telling you is, if that were true, then mom's will was not necessary, that there was some other mechanism for assets to get transferred, because the will has zero legal effect unless it goes through probate. If we need the will to see where something goes, if we need the will to see who's in charge, then it has to go through a full decedent's estate or a full probate, which is going to take a minimum of 5 months, but typically about a year. Okay. And it has to do that. The will doesn't, you can't take the will to the bank. You can take the will to the bank and they'll say, where's your court order? You can't take the will to the realtor. The realtor is going to say, where's your court order? Okay. And so, but sometimes what people do is they have things like transfer on death or beneficiary designations, or they put their kids' names on things, which is a really bad idea. Don't do that. Okay. I'm going to talk to you about that in a second, but it's a really, really bad idea. I've had so many disasters and so many horror stories from parents putting their kids' names on accounts or putting their kids' names on houses. And it's just gone bad so often. Sometimes it's bad for the kids. Sometimes it's bad for the parents. It's such a bad idea. I'm going to give you some examples in just a minute here. Now you see that the beneficiary designations and the will and all those after death things, they don't overlap with the lifetime. So sometimes people say, well, I've just got beneficiary designations. Okay, well, what happens if you get sick? The beneficiary isn't going to be able to make decisions. So, you know, and I told you it's not a good idea to put your kids' names on accounts. So you see that there is a little bit of overlap that covers things during both lifetime and after death, and we call that a trust. So I'll explain the trust in just a minute here, but the idea of the trust is really, it's just a contract. And so we know what contracts do, right? We have an idea of what contracts do. We kind of lay out the terms and understanding of things. And a contract, it's a contract between you and your family. And it empowers the people that you love and the people that you trust to be able to follow your wishes without having to go through the court process. So it basically has 3 different categories that are going to be covered during that trust. The 3 parts of the contract are going to be what happens when you're alive and well, what happens to your stuff, your assets, your dollars, everything that you're in charge of when you're alive and well. And of course, with the trust, the answer should always be, you get to do whatever you darn well please, right? If you're alive and well, you're in charge, you get to do whatever you want, no issue, even with the trust. So don't worry about that. Sometimes we hear about, you know, people in movies or rich kids having trust funds or something like that. That's not what we're talking about here. You're in charge of your own trust. You have a trust, it's fine, you're in charge. Then we have that time period, maybe that some of us will experience, where we're incapacitated, where we're too sick. We had a stroke, we have dementia, we have Alzheimer's, something like that. So the trust is going to give instructions as to who should be in charge and what they're allowed to do, give instructions to the people that you love and trust to take care of things if you're sick, and without having to go through lawyers and go through a court and all of that. And then that third category is what's going to happen after your death. And that is, you know, who's going to be in charge, who's going to get what. But there's also some other things that can go in there to minimize the taxes that you're going to pay. It could help make sure that the kids are going to be protected from divorce and losing the assets to creditors and losing the assets to other things. So there's a lot of things that the trust can do in that third category of what happens after your death. And there's benefits to the trust that you can't do in any other setting. You can't do through a will or anything else. So here's where we're going to describe the will versus the trust a little bit. All right. So I've been teaching this stuff for a lot of years, and I'm a visual learner. So I tend to be a visual teacher. And I've got these silly little pictures to explain the concepts. So my pictures to explain this, I've got for the will, I call it a funnel. And for the trust, I call it a wagon. So why is the will a funnel and the trust a wagon? Well, the will is a funnel because it will catch anything that needs to be caught, and it'll funnel it down to the people that we want to receive it, right? And so it will basically, let's say it's you got, mom and dad and kids, and you want everything to go to the kids after mom and dad have passed. Well, after both have passed, the will catch things that need to be caught that don't have any other mechanism of transfer. It'll funnel it down to the kids and destroy. That seems like it's a good deal, right? Well, it's that middle section of the will that most people are concerned about. It's kind of hard to see on this graph, but it says the word probate. So in order for us to use that funnel, we have to go through this probate process. Probate process in Michigan is going to take a minimum of 5 months. We cannot, under law, get through probate in less than 5 months. If we have to look at the will, it's going to be a minimum of 5 months. But in my experience, and I've been doing this for 25 years, in my experience, it's usually closer to a year, sometimes longer, but usually right around a year or closer to a year to go through that funnel process, that probate process, okay, versus the wagon. Now, why am I calling the trust the little red wagon? And the answer is, well, it's not a funnel. And I mean that seriously. It's not a funnel. It doesn't catch anything. It's not a catch-all. And so the idea I told you earlier, the trust is a contract, but it's only a contract for those things that the contract covers. And that means that it doesn't catch what assets need to be caught and transferred. It catches only the things that we actually put in there. So when you create a trust, we have a new deed for the house. Once you have a trust, you're gonna need a new deed for the house, and we're gonna redeed that house into the trust, or into the wagon. We're going to want to retitle our bank accounts. We're going to want to change our beneficiaries on life insurance. If the trust is designed properly for tax purposes, we may want to list the trust as a beneficiary on your 401k or IRA or other retirement accounts. Now, that you got to be very careful on that, because a lot of trusts, there's a lot of lawyers out there that do trusts, and a lot of trusts don't have those tax provisions in them. I'm going to say, I look at trusts every day that other lawyers have drafted, and I'm going to say the vast majority of them, they did not put that tax language in there. So sometimes we think about a trust and we say, oh, well, I have a will, I have a trust. Well, that means nothing without reading it. You actually have to read the document. And some lawyers are going to put the language in there to allow you to have a comprehensive plan, and some lawyers are not. And I'm going to suggest that most lawyers don't put those provisions. So if you've ever heard, if someone told you, oh, you don't have the trust list as the beneficiary in your IRA or your 401k, well, it depends on the terms of the trust. There's can be some really significant advantages and potential tax savings, sometimes tens of thousands, maybe hundreds of thousands of dollars in tax savings for your family if we handle the trust properly, but it's got to have that language in there. So it's not like a one size fits all kind of a thing. And so just because some people say, oh, I have a trust, it doesn't mean that it accomplishes all the goals or has the tax savings that you'd want to with regard to your retirement accounts. So I call it a wagon because we got to put the things in the wagon. I also call it a wagon because, like your little red wagon when you were a kid, you were in control of it. You got to decide what to put in there, what to take out and spend, who got to pull the wagon. You get to pull the wagon. If you get tired of pulling the wagon, you got to decide who got to do it next. So you're in control of everything. Another way of saying this is the trust is sort of your rule book. It sets things out in such a way that says, okay, well, we don't need the government. We don't need the court system. We're going to do this within the family. We're going to keep family matters in the family. We're going to make the decisions as a family. We don't need the law, the state's rules, and we don't need to have all of the processes and procedures and costs and delays and bureaucracy of having to go through a government process. We're going to keep it in the family. And that's the goal of a trust. And that's when it's done right, that's the way it works. And we can provide some benefits on to the kids. So let's do a quick recap here. If you've planned, you have a durable power of attorney for health care. If you haven't planned, you might need to go to court and get a guardianship because somebody needs to make medical decisions if you're unconscious, or if the doctors feel you're not competent to make decisions for yourself. If there was a stroke or a dementia or any kind of Alzheimer's, anything like that. If you've planned, you have a durable power of attorney for finances. If you haven't planned and we need somebody to be able to pay bills for you, we'd have to go to court and get a guardianship. and have the court appoint, conservatorship, have the court appoint who's going to be in charge of your money. So when it comes to this, when should you have these? At what stage in your life should you have a durable power of attorney for finances and a durable power of attorney for healthcare? And my answer is when you turn 18. And I'm very serious about that. Think about this. Kids going away for college, it's the first time they have any freedom. Something happens to them. Do mom and dad have access to their medical information? Do mom and dad have the ability to make sure that they can handle the financial aspect of things? No, they turned 18. They're an adult. You don't have any legal rights to any of that anymore, including even medical information. And so it's a good idea that this is for people that if you have somebody that you love and you trust. If you have nobody that you love and you trust, then you probably shouldn't have a durable power of attorney. Then we should probably rely on the courts to appoint somebody for you. But if you have somebody you love and you trust, if you're over 18, you should have these documents. Okay, not everybody even needs a will. Not everybody needs a trust. But pretty much everybody that has someone that they love and they trust should consider having a power of attorney for financial matters and a power of attorney for healthcare. All right. Oh, I don't have to worry about any of that because I've got beneficiaries or payable on death or transfer on death on all my accounts. Or I don't have to worry about any of that because I put my kids on my accounts, which is a very bad idea. Don't do that. That subjects your money to what I call the 4 Ds. You're putting your money at risk. You're putting your assets at risk. The first is divorce. Okay, you list your daughter as a beneficiary. You list your daughter as a joint owner. Well, guess what? If she's a joint owner, if she's on the account, that means she owns it. Doesn't matter who put the money in it. Her name's on the account. She can make a withdrawal from it. Her name's on it. She owns it. She goes through a divorce. Guess what? That money is considered hers as part of the divorce. Now we're in bad shape, right? What if your son runs up some debt and maybe doesn't even tell you about it? So they run up some credit card debt. They have their house foreclosed. His name's on your account. We've got a big problem because now they can come after your money because his name's on your account, his name's on your house, his name's on anything, and he runs up some debt. We've got a big problem. Disability. So we always kind of assume that the order of things will always stick, that the parents will get sick before the kids, that the parents will die before the kids. It doesn't always work that way. So what if your kids end up having a lot of medical expenses? What if, God forbid, they ended up in a nursing home or something like that? Well, if their name's on your accounts, the nursing home and the medical, debt is going to be yours. The debt from that is going to be yours because their name's on your account. What if your daughter's husband went into a nursing home and your daughter's name's on your account? Well, guess what? Your money is exposed to your daughter's husband's nursing home costs. So this is a really big problem. You really don't want to put your kids' names on assets. It's just going to cause all kinds of problems, usually causes family problems too. And there's better ways. We talked about the trust a minute ago. Not only does this trust help you manage things during your lifetime, but it also makes it so that it's easier to manage for the kids. If they have to step in and take over, they'll be able to do that in a much easier fashion, just as if they were on it, but they don't have the liability of being an owner of the account. So having them on, they can be a co-trustee of the trust, have access to the account without owning the account. And that's what we generally would want. If you get too sick to manage things, if you get to the point where you'd want some help from your family, we'd want them to have access to be able to help you pay your bills. We don't want them to have ownership of it, because as soon as they have ownership of it, then we've got problems. We got liabilities. And of course, death. What if people die in the wrong order? Okay, so generally, the bottom line is you don't want to just use beneficiary designations. You definitely don't want to use joint owners where you're putting your kids on accounts or using, quick claim deeds or even ladybird deeds. If you've planned, this is again getting back to the recap, we have a will or a trust. If you haven't planned, we have this thing called intestate. So intestate, the idea of intestate is basically the state of Michigan has written a will for you. Okay, so they've written a will for you, and it may or may not follow your wishes. It may or may not have who should be in charge. Okay, this is particularly difficult and particularly a problem in the event that that you have a blended family or a second marriage or something like that, because what happens is if you're intestate, if you don't have a will or a trust, and it's a second marriage, or you got his kids and her kids, then we've got a real problem to the extent that you will not. It's going to go to the one set of kids are going to be cut out. Okay, one set of kids are going to be cut out, and not have. It's going to, whoever lives longest, it's going to go to their kids, the family home, the investments, all of that. Because typically what happens is the first spouse dies. First spouse wanted to make sure that their spouse was taken care of, so everything goes to the other spouse, and that the second spouse to die has kids. Their kids are going to get the inheritance. The kids of the first spouse that died, they're going to be cut out completely. Not because it was intended, not because that's what dad or mom wanted, or either, or maybe both of them wanted, but because of the intestate laws. And there's a bunch of other examples of why just using intestate is a particularly bad idea. All right. This kind of goes to that. I'm going to get a little deeper into this. Could you accidentally disinherit your family? So I've got 3 examples of accidentally disinheriting your family. The first is your spouse. Okay. I was just looking at a trust minutes before we started this presentation. I was just looking at a trust that potentially could have disinherited their spouse. Why? Because a lot of trusts that are a few years old, they would be relying on the old tax law. So sometimes, for example, we would have trusts where each spouse has their own trust. So it's a family that's been married for 50 years. The kids are from this family, and they have a wife trust and a husband trust. Or they have a joint trust, and the joint trust was trying to take advantage of the old estate tax laws that would allow for them to pass on more money tax-free. But because it's the old laws, what it did is it actually divided up the assets in a way that made sure that the surviving spouse didn't have access to everything, so that they would pay less taxes on it. Well, that law is out the window. That law doesn't exist anymore. And so a lot of trusts that are older than a few years, certainly any trusts that are older than about 2010, but any trusts that are even some that were drafted after 2010 may have these provisions in there that say family trust and spousal trust, or AB trust. There's a lot of different terminology that the trust can use that would end up putting restrictions on the surviving spouse having access to everything. I've even seen some trusts that, because of the formula that's used in there and because the tax law changed, it basically completely disinherits the spouse, because it creates this family and spousal trust after the death of the first spouse, and the formula that's put into the trust ends up with everything in the family trust and nothing in the spousal trust, which basically disinherits the second spouse. Not the second spouse, but the surviving spouse. How do you know if your trust has that? Well, I'd be happy to take a look at it. You have an opportunity to click on that button and schedule a 15-minute. We'll do a 15-minute interview, see if it's something that we can do for you. Happy to look at your trust to see if it has any provisions in it. Almost all of the people that had that provision in there that either partially or fully disinherited their spouse because of the old tax law did not realize they had that in there. You know, some of these trusts, I saw one today, it was about 100 pages long. And so they did not realize within that 100 page, it had provisions in there that were obsolete. But not only were obsolete, we're going to cause continuing problems because it incorporated the old tax law. That law changed, and it basically partially or fully disinherited the spouse. So I'd be happy to look at that, but this is why you can't just get a trust and set it on the shelf and never look at it again. Happy to look at that. You can click on the button, and you will be able to schedule a free 15-minute call with us to see whether or not you interview us, to see whether or not you would want us to have review your trust. What about death and remarriage? We just talked about this a minute ago. So one spouse dies young, the other one eventually remarries. What do people do when they get married? Well, eventually they typically buy a house together, right? Well, if you have a house together, you're probably going to have an account together. Well, then after a few years of marriage, what do you typically do? Well, I want to make sure my spouse is taken care of. Even though it's my first spouse died and my second spouse, I want to make sure they're taken care of. So we're just going to leave everything to my spouse. Well, what's going to happen if you do that? So you're now commingling the assets with the new spouse. Even if you had an old trust, a trust before your marriage, even if you had a prenuptial agreement, if you commingle those assets with your second spouse, what's going to happen? First spouse is going to die, first spouse to die. Second spouse inherits everything, or is beneficiary of everything, or is joint on everything. And what's going to happen to your kids? They get disinherited. So, and people don't think about this. They say, okay, well, I got my will, I got my trust, and she's got her trust. And so everything will be fine. We're going to leave everything to my spouse, but then it's going to be divided among all the kids. But that's not what her will says. And that's not what your will says. And that's not what the prenuptial agreement says. But once you commingle the money, that's all thrown out the window. Even if you had a prenuptial agreement, even if you had a trust, you commingle the money, all of that's out the window. So it's very easy to disinherit your children if you get remarried later in life and end up commingling the money. Okay. So there's a way to avoid that, to make sure the trust doesn't allow for that. All right. And then, of course, the blended family situation. And we talked about that. So this is a situation where we want to make sure we provided for the spouse. We want to make sure we provided for the children. Really, the only way, it's complicated enough, the only way to make sure that this is going to be fair and equitable and not based on chance is a trust. You really can't do it with a will. So if you have a blended family, his and hers kids, if you're had a remarriage, then, and you just have wills, and you want it to be fair, you want to make sure that people don't get disinherited unintentionally. The only way to really do that is to do a trust, and we can make sure that the spouse is provided for, that the family is ultimately going to be included and not disinherited. That can be done through a trust because the trust has flexibility. The trust has many layers to it. That's why it's so many pages. Sometimes people complain the trust is so many pages. It's that way for a reason, because we're trying to make sure that we've thought of everything, that we have an answer for everything, that we make sure that we do have the spouse taken care of, but that ultimately all of the kids are going to be included, or they're going to include to the extent that you want them included. Okay. Very, very important. Okay. Some frequently asked questions. I thought these were very interesting. What's the difference between a revocable trust and an irrevocable trust? And most of the trusts that you would have, most of the trusts that people are going to have is going to be a revocable trust. That means you're fully in charge. You can change it whenever you want. You can do what you want. You're in charge. It's your trust. You're in charge. That's the revocable trust. You can change it up until your death, right? Irrevocable trust. There's lots of different types of irrevocable trust, and we use them for very specific reasons. If you have an irrevocable trust and you're not sure why, then you should probably click on that button and have a 15-minute call with us. Because if you have an irrevocable trust and you don't have a very specific reason why, it's not probate avoidance. That's not an irrevocable trust, because both types of trusts can avoid probate. But an irrevocable trust has to have a very specific reason. This is why we did it. It's either for tax savings or protections from the nursing home, or, whatever it is. And so the irrevocable trust, what's the main difference? You have to give up some control and access to it. Now, it depends on what control and what access, and it depends on who you're giving that up to and all these other things. But an irrevocable trust, you cannot have complete control and access if it's an irrevocable trust. If the revocable trust, you have complete control and access. You can change it. Irrevocable trust, there's going to be a different way that where it would have to be changed. You can't just change it by changing your mind. You can't just change it by, your signature. And you're going to give up some control and access. So if you have an irrevocable trust and you're not sure why, you better come in. We'll be happy to look at it and help you figure that out. How should you finalize your last wishes? There's so many different options out there for people to express their wishes. My only requirement, or my only thought on this, is we also want to make sure that we have a legally binding document. So there's a lot of different forms out there. Some of them are really good. There's the 5 wishes. There's other things that we can kind of lay out. But not all of those are going to be legally binding. And given a situation, if there's a situation at the hospital and it's whether or not you should be on life support or those types of things, we're going to want to make sure we have clarity and that we have a legally binding document. And not all of the forms that get handed out by the hospital, not all the forms that get handed out and handed around at church are going to be legally binding according to Michigan law. So it's just, we can have those things. I really appreciate those things where we're getting into detail about our wishes, and I think those are great. I think that you should absolutely do those. But in addition to that, we need to make sure we have a legally binding patient advocate that complies with all the requirements of Michigan law. How do you calculate the value of your estate? This is actually a really interesting one because people almost always undervalue what they have. They think that if I ask them the question, well, if you add everything up about how much it is, they almost always undervalue it because we've got to look at obviously the house, the vehicles, life insurance, personal effects, all those types of things. Often we forget about the life insurance. Often we forget about some death benefits, things like that. But the other thing, and this is interesting how the courts handle this, when the courts, the probate courts in particular, when they look at the value of an estate, for example, a house. So let's say you have a $400,000 house and you have a $300,000 mortgage on it. What's the value of that? Well, you and me, any rational person, they would say, well, the value of a house that's worth $400,000 has a $300,000 mortgage, so your value is $100,000. Probate court looks at that and they say for the inventory, that's a $400,000 value, even though you owe $300,000 on it. But when they're determining the inventory fee, they're going to calculate the value without looking at the mortgage. And so sometimes when you're looking at how to calculate your estate, you have to look at it the way that the government would look at it. And then I added this last one because I thought it was kind of funny. How do you make sure that your idiot son-in-law does not get your money? Well, idiot son-in-law, the daughter-in-law that you don't like, any number of other things. This goes back to the issue of the trust. Well, with a trust, you can set out provisions for after your death that can provide some benefits and protections and help for your heirs, for your kids, to make sure that they have access, that they have the ability to control the money, but it wouldn't be subject to divorce. It wouldn't be subject to your idiot son-in-law getting his hands on it. Potentially it wouldn't be subject to nursing home costs if they were in a nursing home. Potentially wouldn't be subject to debt. So if they had some outstanding debt, but they get an inheritance from you, is there a way to make sure that the inheritance you get doesn't just get eaten up by their old debt? Yes, there's a way to do that through a trust. Okay, so these are very important questions that we can go over. And if you have questions about that, feel free to schedule that 15-minute interview. And then the big question that everybody has is, well, what am I going to pay in taxes? So I have a cute little video I'm going to show you, and we're going to show you that real quick here. I definitely agree. Taxes are the worst part of the game. I can sympathize with Donnie. I don't like paying taxes either. All right, so I've got some good news and I've got some bad news. And the good news is if you're a Michigan resident, now this doesn't apply to other states. Several states, lots of states still have a inheritance tax or death tax. Michigan does not. Michigan does not have a death tax. That doesn't mean the federal government doesn't. But for most people, you're not going to pay an estate tax. The current federal exemption is over $12 million. That doesn't mean that we're not going to have any taxes when you die, but it's not going to be a state tax. There's still going to be, this is the bad news. So that was the good news. You probably won't, if you're a Michigan resident, you're probably not going to pay any death taxes or estate taxes unless your estate's over $12 million. You still probably will. The family will still probably pay taxes, but it's not estate taxes. It's income taxes on your retirement accounts, okay? And this is where the trust can really come in handy. So we can set things out in such a way in the trust, take advantage of the new law called the Secure Act to make sure that we're going to minimize those taxes for the next generation. And under the Secure Act, it basically lays out three options for how things are going to get taxed. Retirement assets like IRAs, 401ks, Roth IRAs, any type of retirement account, how that's going to get taxed to the family. The first option is that it would be taxed over 5 years. Second option, it's going to maximum would be 10 years. And the third option, it could be extended even beyond 10 years. So what we like to put into our trusts is to make sure that we have all of the best options available and that we can make the most reasonable and best options to preserve the money for the family. More money goes to the family, less money goes to Uncle Sam. I did a whole presentation on this recently. I'd be happy to discuss it with you and how it relates to your specifics. The way to get more information about how you're going to pay less taxes or how the family's going to pay less taxes on retirement accounts using trusts, you click on that button and we'll have that 15-minute interview. Okay, free interview, doesn't cost anything. We're going to set up that 15-minute interview. We'll see where we go from there. And then finally, the tax consequences of lifetime gifts versus inheritances. So for many generations, people thought, okay, the best thing to do is start giving away my things, start transferring my assets during my lifetime. Well, anything that increases in value, that creates a very, very big problem for you. Because if it increases the value and you've transferred it, you made a lifetime gift versus having it go to them through an inheritance, then they have this thing called tax basis. So tax basis, the best way to understand that is if you bought a stock and you buy stock at $20 a share and now it's worth $40 a share. Well, the tax basis was 20, so you sell it at 40, you got to pay taxes on the difference. That extra, you got to pay income taxes on the difference. Same thing with real estate. You buy real estate at 50,000, you sell it at 100,000. If it's not, unless you have exemptions, there's going to be taxes on the gain. If your kids you gift appreciable assets that increase in value to them during your lifetime, they're also going to inherit your tax basis, meaning the lower dollar amount, and they're going to pay capital gains taxes. Okay, if they inherit it, they don't pay capital gains taxes. They have this thing called step up in basis. So you have a vacation property, you have the cabin up north. This typically doesn't apply to your residence, okay? Because with your residence, you have an exemption. But you have the cabin up north. You bought it for $50,000. It's now worth $250,000. If you gift that cabin up north to your kids, they're going to pay taxes on $200,000 gain. If they inherit it, they will pay zero taxes because they will inherit it $250,000 as the tax basis instead of being gifted your tax basis of $50,000. So if you gift the asset during your lifetime, you gift the cabin up north during your lifetime, the kids will end up paying a huge amount of capital gains taxes versus having it go to them through a trust or even a will, and they will probably not pay any capital gains taxes because they have this thing called step up in basis, but only for an inheritance. All right. So big, important thing. Okay, I mentioned that I talked to you about, well, what happens if you don't die? And what if you don't die, basically meaning that, what if you got sick? What if you had a stroke? What if you had Alzheimer's? And so the question I pose is, will I lose everything if my spouse or I get sick or go to a nursing home? You have a massive stroke. You have Parkinson's. You have MS. You have dementia. You have Alzheimer's. Whatever it is, you require. A lot of people would just assume, well, if I get sick, isn't my insurance going to pay for that? Isn't Medicare going to pay for that? And the answer is no. Medicare might pay for a heart transplant or a heart bypass, and your insurance might pay for that, but they don't pay for continuing care that's needed if you have Alzheimer's. They don't pay for continuing care, long-term care is what they often call it. If you have any of these diseases that require long-term care, okay, they're not going to provide you daily care. And so how do you pay for that? Well, the answer is you can just pay for it out of your pocket and potentially spend down everything. Or with proper planning, and this is part of the estate planning, we have these things that we incorporate into our planning called extraordinary powers. That's going to allow for your family to be able to protect assets and qualify for Medicaid if it's necessary. So we can talk about Medicaid. If you have questions about Medicaid and whether it's ever going to be something that you'd want to consider, not Medicare, but Medicaid, then you'd want to click on that schedule here button and we'll have that 15-minute call. But here's the bottom line. I'm going to cut to the chase. If we have somebody that comes in and they end up having, severe dementia or severe Alzheimer's or a severe stroke or something like that, and they're going to need 24-hour care, we have people come in every day in this situation. and they're told, okay, well, you're going to need 24-hour care. It's going to cost somewhere between $6,000 and $10,000 a month to provide this care, and Medicare and your insurance isn't going to pay for it. What can we do? Well, one of the things we can do is we can qualify for Medicaid. With proper planning, if it's a married couple, I can protect most of the time 100% of the assets in favor of the healthy spouse. There's some safe harbors built into the laws, into the Medicaid law, that would allow us to help to protect the healthy spouse, to make sure that she's not going to get the healthy spouse, he or she, is not going to be impoverished as a result of their spouse's illness. So typically, maximizing those safe harbors, they can protect 100%. What if it's a single person? Well, even with a single person, if I have proper planning now, I want to have that proper planning before they get to the point where they can't manage it anymore. That's why it's important to do this planning now, to have these extraordinary powers now. If we don't have them now, we're going to be in much more trouble to be able to protect anything in the event that you need care later. So you got to put these things in place before you get too sick. But with a single person, we can usually protect the house, a car, and at least 50% of everything else. Now, that sounds not quite as good as 100%, right? But when you think of it in comparison to the alternative, with most of the time with Medicaid, if you don't do proper planning, you have to spend down to $2,000. So this is a big deal, and it's important that we have that planning while you're still capable of doing the planning. So we're going to look through some questions here. I have a question here that says, with a trust, does it require an accounting or an inventory of assets that have been done because a parent passed 3 years ago, and she waited to sell the house? Do you have the right to an accounting or an inventory with a trust? And there's two things. Number one is typically the trust is going to require that's require both an inventory and an accounting, and that you get a copy of the trust. So you should be able to read it in there. If you're a beneficiary, if you're a child or what they call an interested party, you should be able to get a copy of that. Typically the words of it are going to require that. But if not, we have in Michigan the Michigan Trust Code. And the Michigan Trust Code is also going to require that you get those types of notices unless the trust specifically says that you're not entitled to that. How do you enforce that? And the answer is, unfortunately, even with a trust, if there's this type of dispute and the person who's in charge is refusing to follow the rules, you have to file a petition in court, in probate court. So the probate court's still out there with regard to a trust. We typically don't have to use it, but when things go wrong, that's what courts are for, to help protect things in the event that things go wrong. So very good question. What happens to unmarried partnerships owning property together and trust? This is a great question. This is such a good question. So we have an unmarried couple and they own property together. We better have a very clear laid out plan. Do we have a joint trust? I've done that many times where we have a joint trust just for the joint property that has specific terms as to what happens. Think about this. So we have an unmarried couple and we say, well, we both put money into this house or this property. I wouldn't want the other one to be disenfranchised from that, but I also want to make sure my share goes to my family. So we got to lay that out. We got to set it out terms that says, okay, if one of us dies, what's going to happen? How is that person going to be protected? The other partner be protected? And then how are we going to make sure that if I die, that once that house is sold or the asset is dealt with, that my family is going to get included into that? Well, you could very well do that in a trust. You could do that in a partnership agreement. You can do it in an LLC. There's a lot of ways to do it. I tend to favor the trust because I think it's the most flexible. We've even had a situation where we had partners that owned property together, and the one partner said, well, I want them to be able to continue to live in the property, but I want my share to go to my kids after they don't live in the property. And I said, well, what about if, because that's a pretty big house, what if they wanted to downsize? And so we set up the trust to say, okay, if they downsize, part of the money, the extra money would go to the kids, but they can downsize it as long as they take the money from the sale of the house and invest it in a new house that's in the trust. They'd still be able to do that too. So trust can be very flexible to solve these problems, but they're very important to solve those problems. So it doesn't look like there's any other questions here. We're going to wrap things up. I highly encourage you to consider scheduling. There's the little button there. It says schedule here. What we do is you're going to have a 15-minute call with somebody in our office. Usually, what you're going to need might be more than the 15 minutes, but they're going to talk you through. First of all, you get a chance to interview us and decide whether we're the right, law firm for you. And we get to interview you, make sure you're the right client for us. But then they kind of lay out what would happen going forward. And there's no obligation, no risk involved in that. One of the things when it comes to estate planning is that typically we will meet with you for a full meeting, not just the 15 minutes, at no cost to review your estate planning. Other things we have to charge you for that first meeting, but that's why we have this 15-minute call, so that we can figure out the process forward. There is one other question that talks about, well, what if children receive disability? What if anybody in your family receives disability? You definitely need specific estate planning. It's not that difficult or that expensive, but it's so important to have estate planning that's going to protect them, make sure that they're able to maintain their medical benefits and their disability benefits. It's not that difficult to set that up, and there's a lot of options and variety, especially if they're going to get an inheritance. But it's really important that be reviewed and be done by a qualified attorney to make sure that you have an appropriate plan. So thank you for your attention. Thank you, everybody, for coming. Please feel free to schedule that 15-minute free meeting where you can interview us, and we can figure out where to go from there. So thank you very much. Appreciate your time.